All right, well, good morning and welcome to the Maryland Public Service Commission's April 18, 2018 administrative meeting. Our first order of business, of course, is I'll start with a motion to adopt the April 11th administration minutes. Is there a second? Second, great. All in favor?
Aye.
Opposed? The motion is adopted. I'll turn to our Executive Secretary for today's agenda.
Thank you, Mr. Chairman. We don't have a consent agenda this morning, but before we begin, we're going to defer items 5 and 6 on the agenda to a future administrative meeting. So the first items we have on the agenda this morning, items 1, 2, and 3, I think we're going to call collectively together. There are filings from Calpine Energy Solutions, LLC, Champion Energy Services, LLC, and North American Power and Gas, LLC, all filed a notice of change of control.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. These three items address the acquisition by Energy Capital Partners, we'll call them ECP. They purchased Calpine Corporation, which is the parent of 3 electricity suppliers in Maryland. As a result of this acquisition, ECP is now the indirect parent of the 3 suppliers. The merger will not affect the suppliers' operations. There are no unresolved complaints against the suppliers, and each of the suppliers is up to date on their payment of commission fees. Therefore, the staff recommends that the commission note the acquisition.
Thank you. Are there any questions?
Yes, thank you. Good morning. ECP has acquired 3 companies that have licenses to provide deregulated service in Maryland. At least 2 of these companies are pretty active in the residential market. So do we know anything about ECP Partners or EC Partners?
Yeah, Commissioner, you raised this a couple of administrative meetings, asking staff in the future when we have an acquisition to be checking on the acquiring company, and we are doing that with this entity. In fact, I have their email. They told me that ECP has confirmed that as of March 2018, neither ECP nor any of its affiliates operates as a retail electric or gas provider in Maryland or any other state. We did, in other words, raise with them specifically with ECP to get an idea of their performance in other states and that of their other affiliates. So they're sort of an investment firm, and this may be their first foray into retail setting. So that's the information we received in response to that.
Okay. Do we at least know if they are going to, for those customers that already have contracts with one of the 3 suppliers, are they going to at least honor those agreements that are currently in place with those consumers that are here in Maryland?
Yeah, that's my understanding. This is at the parent level, or the indirect parent level. It's actually one level up from that. So there's no impact on the existing operations or products that each of these suppliers is providing.
Okay. All right, thank you very much. And thanks also for looking into it a little further. I think it's useful for us to know a little more about some of these companies that are acquiring the supplier licenses to do business here.
Yes, like I said, in response to your specific comment on this a couple of admins ago, we are doing that.
Okay, thank you.
Thank you, Commissioner. Any other questions? Okay, hearing no questions, do we have a motion?
Yes, Mr. Chairman, I move with respect to items number 1, 2, and 3 that we note the change in control.
Okay, is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted.
Next item on the agenda, item number 4, is the Potomac Edison Company filed a request for a waiver of the CPCN requirements to run a transmission tap line.
Good morning, Commissioners. Michael Dean on behalf of staff. Item 4 is a filing by the Potomac Edison Company requesting a waiver of the requirement under Public Utilities Section 7-207 to obtain a certificate of public convenience and necessity prior to commencing construction to install a tap line from the 138 kilovolt Ringgold to Catoctin transmission line to install a new Garfield distribution substation located along Tower Road west of Cunningham Falls State Park. Generally, Public Utilities Section 7-207 requires a person to obtain a certificate of public convenience and necessity prior to commencing construction on an overhead transmission line with voltage in excess of 69 kV. However, under Section 7-207B4I, The commission is to waive the requirement if the commission finds that the construction does not require the company to obtain new real property or rights of way by eminent domain or require larger or higher structures to accommodate increased voltage or larger conductors. The following reports that the planned work will involve the addition of 3 new inline 60-foot wooden structures, which is consistent with the existing structures of this line, which are on average 62 feet high. The company has binding options on the property for the substation and connection right here. The work, which will commence in July 2018, will improve the reliability of the distribution system by dividing up the existing Wolfsfield circuit, which it runs 114 miles and has been previously listed as a poorest performing feeder. Staff finds that the proposed tap line meets the requirements for granting the required waiver. Staff comments also discuss the effect of the proposed TransSource transmission line, which is currently under review in case number 9471, and provides additional background information on the proposed work on the transmission line. Staff notes that the Commission has approved similar waiver requests for tap lines on overhead transmission lines in the state. Staff recommends that the Commission grant the company's request for a waiver of the Certificate of Public Convenience and Necessity requirement under Public Utilities Article Section 7-207B4I to permit the company to build the transmission tap line from the existing Ringgold to Catoctin line for the new Garfield substation.
Thank you. Let's see, I have just a couple of questions. I would like to understand the staff recommendation in this case. So what I understand we're doing here is approving the waiver, but are we also approving the project itself, the type of project, this tap line? In other words, it's for a 130 kV structure, capable structure that could be changed may need to be changed later to a 230 kV structure. Is that what we're doing? We're actually designating what kind of structure this is going to be.
If the waiver is granted, the company will install the 138 kV wooden structures.
Okay.
Any other work would have to be approved under, assuming that the Commission does grant the proposed TransSource transmission line, that will govern the additional work as necessary.
Okay, so that's how I guess may have meant it. This will be impacted, or could be impacted by a decision on TransSource. Is that correct? So
that's correct.
Okay, and so the reason staff though is still recommending we do this now urgently. Do I understand from this it's for reliability purposes?
Distribution reliability.
Distribution reliability purposes, and that's even in face of the fact that we may then be back here allowing, I guess, an upgrade because of a possible decision on TransSource. In other words, additional costs may have to go into putting in, I guess, the 230 capable poles.
If the TransSource transmission line project is approved, and that's a transmission system reliability project.
But at this point, though, if we do make that decision on TransSource, then PE customers will be on the hook, though, to then pay for the upgrade. Is that what we're being asked to make a decision on now?
That's not exactly correct. The cost of any upgrades for the TransSource transmission line will be allocated through the transmission line tariffs if that's approved.
Okay, so okay. I just wanted to.
So
that's where I was.
It would not be specifically Potomac Edison customers that pay for it. It's likely that will be a more covered under more of the zones under PJM.
Okay, and that's the case. Again, I wanted to go to, I guess, one of the data requests, where it was my impression that that was still in question as to who would pay. And according to the data request, staff 2.7 says, please advise who will bear these costs, Potomac Edison or Transource. And then the response is, it has not been finally determined how the cost would be allocated if the Garfield tap line has to be later rebuilt because of the Ringgold-Catoctin 138 kV transmission line is built. And then it says it would be, well, PGM would determine cost responsibility assignments in accordance with Schedule 12 of the PGM tariff as described in Mr. Rostock's testimony in case number 9470. So do we know now that if we do move forward with the Transource project, that these costs for improving then this tap line will be allocated to all the customers, all the beneficiaries of the transmission line, and not just PE customers?
Well, given that it hasn't been approved yet, there's no document on the allocation of costs, but transmission line upgrade costs, including the work that's done at the interconnections, such as in the future here at the Potomac Edison substations, those are generally included in the transmission line costs.
Okay, so that's
And they say
a rule generally. Okay, we can count on that happening in the future.
Yes.
That this uncertainty that seems to be
Yes.
indicated in this response isn't so uncertain. Should we move forward with Transource?
There's no reason to suspect that the actual allocation will be different than what's been in the past for these types of projects.
Oh, okay, great. Well, thank you. I have no more questions.
Couple questions. Thank you, Mr. Chairman. I wanted to ask, notwithstanding how things are allocated, should we go forward, would it be more prudent, and has staff considered recommending that we wait on this until a decision on Transource is made so that we don't potentially have to do the work twice?
Good morning, Commissioners. John Borkowski for staff. This is a dilemma, and we described it as a dilemma in our box sheet response, in that, yes, there will be significant additional costs to the tune of about $1.6 million. If Potomac Edison goes ahead with their current plans at 138 kV, Transource comes in, and if it is eventually approved, that substation transmission costs combined would be about $4.6 million. The problem is that with waiting is that we have a poorest performing feeder in Maryland. It's been on a poorest performing feeder list for several years, intermittently. I think it was 2012, 2013, 14, and again in 17. So it'll be a repeat poorest performing feeder. The company has already performed a lot of different remedial mitigation activity with that feeder, just because of the fact that it's 114 miles of feeder length total. That includes the laterals off the main line, but just because of the fact that it has so much distribution exposure, there's only so much that you can do to improve reliability. It goes through a very mountainous, wooded area. There's a lot of problems with off right-of-way trees and things of that nature. The company has determined, and staff concurs, that the best solution here would be to break up the feeder to the extent that you have a new substation supplying a feeder from an opposite end. You have a distribution automation tie in between. That should afford a significant reliability improvement for these customers. So getting back, Commissioner O'Donnell, to your first question, I felt like I had to set the stage for that a little bit. But getting back to your original question, you know, if you waited for TransSource decision, it would be at least 3 years and perhaps more. We really can't comment on the TransSource case. That's an ongoing case, but it would be at least 3 years to wait. So staff did not feel that it was reasonable to delay the reliability improvements in this case for waiting for the outcome of a case that we really don't know what the outcome is going to be. So that's the basis of proceeding ahead with staff's recommendation to approve the CPCN waiver as submitted. I would point out also that it's my understanding this is a mandatory waiver request, and meaning it's under the mandatory clause of the statute. So really, while there are other options available to PE, they did not submit under those other options, and we're only evaluating, their original request here. But we did feel, because of the complexity of this case, that we would offer up a full picture, a full view of the different trade-offs involved in making this decision. But it really is PE's decision, and again, staff doesn't feel like it's reasonable to expect the customers to wait 3 years or longer to get their reliability improvement while waiting for, the outcome of an uncertain case.
So 2 follow-ups, and I appreciate that, Mr. Borkowski. One follow-up is, what is the construction timeline, assuming we approve this CPCM waiver? What is the construction timeline for this new substation in terms of major milestones? And then 2, what did you factor into a 3-year estimate on a TransSource decision?
Okay. Well, first, if approved today, the project would begin in midsummer and would be completed by the end of this year, so that customers would begin to experience reliability improvements in 2019. So that's relatively immediate. With regards to your second question, it's my understanding, based on the way the TransSource case is laid out, we really don't have a direct testimony due until the end of this year. Hearings will be next year, and the decision would probably be sometime later, at the earliest in later 2019. I guess given that at that time, knowing the outcome of the decision, the company would have to elect, actually would have to design the station at 230 kV and procure equipment. If it's likely, and the company has indicated in data requests, it's likely that you would not have a solution until the end of 2021, so the reliability improvements would not be effective at the earliest until 2022.
Yeah, it seems to me like the delta between finishing construction on this and a TransSource decision is probably closer to 6 months, 6 to 12 months, not 3 years, but that's, I guess, reasonable minds could debate that. I'm just trying to make sure that we're not doing work twice that we don't have to do and paying for it twice, because the customers have to pay for it twice should we approve that, and that's a concern for me, of course. And I know it is of staff as well, and it's always a trade-off between reliability and costs. You can have the most reliable system in the world if you're willing to write an unlimited check for it, but it's always a trade-off and a balance of priorities, and so that's what you're hearing being probed right now from the commission, is what is that balance point? It's not certain in my mind what it is, but I appreciate the staff's answer and work on this. Let me ask you another question with regard to the mandatory nature of the waiver. So the Public Utility Article waiver requirements say that we grant these if 2 kind of predicate conditions exist, that we don't require higher structures to accommodate increased voltage or conductors, and then the other one is the construction does not require new real property or eminent domain rights. Those are the two basic requirements you have to satisfy first. So the buck sheet alludes to binding options on real property for the construction. Isn't that the acquisition of new real property?
It is the obtaining new real property, but it's not using eminent domain.
Understand. So to me, I separate those two, and maybe I'm reading it wrong. I think it reads acquiring of new real property or eminent domain rights, which could be right-of-way rights, not acquiring the property.
Well, it reads obtaining new real property or additional rights of way through eminent domain. So the eminent domain applies to both of the prior.
So there's no prohibition on acquiring new real property except if it's done through the exercise of the right of eminent domain.
That's correct.
Okay, thank you.
And what that's saying is that if eminent domain is going to be required before taking property from people in the state through eminent domain, we need to make sure that the project is actually going to be needed, so it needs the full review of a certificate of public convenience and necessity.
Okay.
That would be my read of the
So the-
intent of the statute.
So the binding options then on this real property don't violate that predicate on obtaining new real property.
That's correct.
All right, thank you. Thank you, Mr. Chairman. That's all the questions I have.
Other commissioners?
Yes, thank you. Yes, good morning. As a result of the report that staff has put together in this buck sheet, did you get any response from the company as to the different options that staff has proposed here? Did the company consider the other options? What kind of response did you get from them?
Commissioner, I do think that, and the company does have representatives here, they could probably speak to that better, but it's my understanding that, they considered that about a year ago, the different options, and elected to go with this option. But I think that answer should probably come from the company.
Okay, thank you.
If I could just follow up, I had one follow-up question from Commissioner O'Donnell, just, talking about the the fact that we'd still be paying twice potentially for this project, and even if it wouldn't, all the costs would not be going just to PE, is there still kind of a precedent issue here, since we do know that a decision will be made one way or the other in a very reasonably short period of time, to be approving projects that are likely to be impacted by another decision that's coming our direction. I mean, would staff did they consider that as some kind of a mitigating factor? Particularly in this case for the reliability issue. Is that something we should? In other words, there may be other impacts out there that we just haven't come to light yet. I mean, this one came to light because of this request. But are there potentially other distribution impacts from the TransSource line that if we move forward today, we would be somewhat bound to make a decision on those other projects? Or
well, staff is not aware of additional impacts from the TransSource project on the distribution system. In general, the reliability planning on the transmission level is different from the distribution level. One's handled by PJM, and the other is the responsibility of the company. we'll have.
I understand that. Again, this has come to light that this particular project will likely be impacted by the TransSource project. So should that be something we take under consideration before we take on a project like this, given that we may have other projects come to light that are impacted by this TransSource project?
If you're asking, is going forward prudent at a future rate case?
That's kind of where I'm going, yes.
Yeah, at a future rate case, there's always the opportunity to review whether the company's planned work or the completed work at that point, completed work was done prudently. If it's always possible at that point that through a review of the work after the fact, we'll be able to see whether at the time the decisions were made, whether all the information was considered in deciding to go forward with the work at that time.
Okay, and in this case, we're told that this is mandatory, waiver, but at the same time, I mean, is it, at least our prerogative here, I guess, from the bench to say we have concerns about the fact that customers, in this case, are likely to pay twice for the costs.
Well, it's they're as identified in staff's review. There is a certain amount of the work that could be considered to be done over again by should the TransSource project be approved as currently planned. And again, at a future rate case, it would be incumbent upon parties challenging the prudency of the work that was done on the distribution portion that's included in the company's rate base to show that to review it to see that it was prudent.
Okay, all right, thank you. Let's see, we do have the company represented. Would you like to make a statement, comments?
Yes, thank you. Good morning, Commissioners. Jeffrey Trout, Counsel to Potomac Edison. Let me begin by saying that the company agrees with the analysis that was in staff's written comments, and we agree with virtually everything that the staff has advanced as further analysis and explanation this morning, with one qualification, which is about the prudence issue, and I'd like to speak to that. I'd actually like to speak to three items, if I could.
Mr. Trout, can you pull that mic closer to you?
I'm sorry. Normally, people don't have a problem hearing me, especially in this room. First, I'll take the opportunity to answer Commissioner Linton's question. Yes, Commissioner, we did look at all of those options before we finalized our plans and filed for the waiver. And Mr. Bukowski is correct that this is a more complicated and difficult decision to make than normally would be the case. There are several possible courses of action here which would, in our mind, be prudent. There are several possible ways that a reasonable decision maker could proceed. And the one that we chose and the one that we have submitted to you is the one that gets the reliability benefits to our customers at the earliest date that we can, number one. And two, it's the lowest cost one if at the end of the day we do not wind up having to rebuild Ringgold Catoctin to 230 because the TransSource project is not built. The TransSource project needs 4 approvals, 2 in Maryland and 2 in Pennsylvania. If they don't get all 4 of those approvals, we won't be rebuilding Ringgold Catoctin. And we don't know if they'll get all of those approvals and when they'll get all of those, assuming they got them all, how long it would take. The earliest that they could get their approvals from this commission would be sometime next year. I think I'm correct in remembering that the evidentiary hearings aren't until February of next year, and so there'll be evidentiary hearings, there'll be briefing, then the commission will need some time to make a decision. So I would project it would be late next year at the earliest before you had a decision. If we had to then do a rebuild to 230, at that point on the tap line, we'd have to go out and order new hardware, and that's why it spills into 2021 or even possibly 2022 before you see the reliability benefits. Given the choices available to us, we went with the choice that got the reliability benefits earlier, and that under at least one scenario, one possible outcome here would be the least cost outcome. So that's what we considered and why we reached our decision. The second point that I'd like to make is about paying twice. There's about $3 million of costs associated with this project, which no matter how we do this, will wind up being incurred and then will be allocated for on the the distribution cost to the distribution customers, transmission costs through the PJM process. So it's not that the customers would pay twice. It's if we had to go back and rebuild, there are certain things that we would have to change. We wouldn't have to get new real estate because we've already gotten all the real estate rights that we would need in order to eventually rebuild this to 230 if we needed to do that. We did plan ahead in that regard. We're covered for both eventualities. We've got the real estate rights. We've got the substation layout able to accommodate that. So what would need to be changed would be the hardware, and that's described in the data request responses in a bit more detail. So yes, there would be additional costs. We would argue to PJM that those costs would be costs that would be incurred as a result of the TransSource project, and that they therefore should be socialized across through the normal PJM tariff process across PJM in the way that's described in Mr. Rostock's testimony with respect to the Ringgold Catoctin rebuild costs. So I think it's a little bit overstated. I won't say misleading, but it's a little overstated to say customers would pay twice. There would be additional costs if we do have to rebuild this to 230 later. And the trade-off is we don't know now that we're going to need to do that, but we do know now that we have a reliability problem and we want to solve that sooner rather than later. So that's my second point. My third and final point is about prudence, and this is where I'm not sure, but there may be some tension between what Mr. Dean was saying and what I would argue to you. In some future rate case, if there were costs associated with this project that arose from having to rebuild it to 230, what the Commission would be doing at that time, and those costs were costs that would have been included in Maryland rate base, what the Commission would be doing at that time would be asking the question, well, did the decision that the company made in April of 2018, was that a reasonable decision? Not is it the decision the commissioners would have made, but was it a reasonable decision to make? Well, we're standing here now in April of 2018. We contend that there are several possible reasonable ways to proceed. We believe that the best one is the one that gets the reliability benefits to customers sooner. We also believe, respectfully, that that's the company's decision to make as long as it's a reasonable decision. If it's not a reasonable decision, if it's the view of the commissioners that it would be imprudent for us to do this, we don't want to hear that in 2020 or 2021 in a rate case. We're all here now. The question is, are we making the right decision now? So if you tell us now that it's imprudent for us to do this, we won't do it. We're not going to go ahead and do something and then get told 3 years later that the decision we made looking back on it 2 or 3 years later was imprudent. We all know, everybody now has in front of them the facts. We all know what we know now. This is the time to say whether this is prudent or not. But as long as it's a reasonable way to proceed, not the one that would get selected if this were Mr. Bukowski's project or the commissioner's project, but as long as the company has made a reasonable decision, we think that resolves the prudence issue. So there we are on that. So yeah, you could make an argument that it's not the commission's role to say that today. It's your role to just say, well, it's a tap line and you've met the requirements for the mandatory waiver, so go ahead. But I think we'd all be disserved by staying within that box. If you think this is wrong for us to do, tell us now, we won't do it. If you think it's, and by wrong I mean unreasonable, imprudent, not is it what you would have chosen if you were running Potomac Edison, but is it a reasonable choice? Tell us now, we won't do it. We'll withdraw the application, or we'll let you vote it down, whatever, however you want to proceed. But if it's a reasonable choice to make to get the reliability benefits to the customers, even though there is a risk that what is today the lowest cost alternative, proceeding and building it at 138, will incur higher costs later because we have to rebuild it to 230. If that's still a reasonable choice to make, then we should go ahead.
Great. Thank you, Mr. Troutman. And from my questioning, I am very aware that today is the day that we need to be considering these issues,
Yep.
and why I asked the questions to staff to make sure I understood how that went into their thinking when they made their recommendations. So, yeah, I do agree. Also on the cost issue, I would just comment that so often we do hear from utilities, and they will go to the mills of pennies on behalf of the shareholders, and I think it's, at least I consider it part of our job to also think about mills of pennies when we're talking about ratepayer costs. So, again, I understand this is de minimis, but I would like to understand what we're doing here. So, again, are there any other questions here from commissioners?
Yes.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Trout, thank you for being here today. Appreciate it. I wanted to ask you about a couple things. One is, you said that you wouldn't have to acquire new real estate because you already built that into the contingency. Do you know what the difference in the cost was if you only acquired property for a 138 kV project as opposed to 138 kV project plus capacity for 230 kV?
The short answer is that no, I don't. But Mr. Walter, it's here, and I think he may know the answer to that.
Justin Walter, I'm project manager for Potomac Edison for the project. Thanks, Jeff. Short answer is The piece of land that we're purchasing is the same piece regardless of what the size of the substation is. We designed the substation site considering the future possibility of the 230 conversion, but we bought the piece of land that was available for purchase was the same regardless of what the future substation was going to be.
Okay, so,
There's no cost.
okay, so it doesn't matter then, it wouldn't have mattered either way.
No,
Okay,
it's a 5-acre piece of ground no matter what the substation.
all right, fair enough, fair enough. I just was cued into that line of question by we built that into our planning, we won't have to acquire more property. But it really wasn't by planning, it was a matter of the parcel size that was purchased. Okay, how long has this project been in the queue for planning and development?
We have been developing this project since 2014. It was delayed initially because we had some trouble finding a piece of property where we could locate the substation. But yeah, we've been developing it long before we knew anything about a Transforce transmission line project.
Yeah, that's my sense too. I mean, I don't think anybody disputes that the reliability upgrade is probably needs to go forward. At least I'll speak for myself. I suspect that it probably does because of the poor performing feeder aspect of it. But the notion that we might be forced into making a decision expeditiously, and that expedition may cost us or cost the ratepayers more money in the long run, is concerning to me. This project's been in development for 4 years, sounds like at least, and now we're forced to make a prudency review in an AM on a $3 to $4 million project, and I think that's why you're hearing some of the line of questions that you're hearing, because it does cause some indigestion for me.
Commissioner Herman.
Mr. Trout, I'm going to disagree with you. Mr. Trout, would you agree that this is a citing statute?
I do.
Okay. Do you see any record for us to make any kind of a prudency review at this time, in this situation?
It is entirely within your power to make this decision in the four corners of the statute and without addressing prudence. That's correct.
Right. And wouldn't we normally make a prudency review if there were even any distribution costs? I mean, these are transmission costs mainly, are they not? Or are they distribution costs?
The most of the cost of the project as we propose to build it now are associated with the distribution substation. The majority of the costs.
Right.
If we later have to change the voltage on the tap line, the majority of the costs associated with that change would be transmission costs.
Right. That's where I was headed. The majority, if you have to change it, it would be transmission costs.
Yes.
And those would be considered in the FERC, transmission rate
Yes, that's our
process.
position.
Is that
Yes.
right? Okay. So, Mr. Trout, I just want to be clear for the record that I disagree that we are making a prudency, and to the extent we have a mandatory waiver requirement, I want to be perfectly clear that in my view, we are not making a prudency decision or review at this time, and this is not the appropriate time to do that. So I just want to be perfectly clear that I disagree with your assessment earlier.
I understand and respect your position, Commissioner, and I believe your position is probably consistent with staff's position as articulated in their written comments. My response is predicated on the concerns that have been raised by others on the Commission, by staff's discomfort as evidenced by all of the information that they collected, which was really sort of outside the scope of did we meet the requirements of the waiver statute, and just by the fact that we're here now. We know what we know. The idea that we're going to get in a time machine 3 years from now and then come back to here doesn't seem to me to be efficient. If someone has, I believe if the commission has a prudence concern and doesn't think we should go ahead with this would be a good time to articulate it.
Well, again, I think that, you are, in a proceeding, you could argue that the decision was reasonable at the time that it was made, and that the commission doesn't need to make that decision here and now. And in fact, anytime one does distribution planning, you do take some form of a risk. You expect load to increase, the load doesn't increase. That can be, those decisions are reviewed at the appropriate time in rate cases, and that, the citing authority for whether or not you've met the terms of the statute, that is a completely different question, in my view.
Understood.
Thank you.
Follow up.
Sure. Commissioner O'Donnell?
So there's no guarantee that FERC will allocate, should we upgrade to 230 kV, any PJM recommendation that they traditionally have. There's no guarantee to that. They could do something novel, right?
That's true, yes.
So that may be a factor going forward that we should consider in a future proceeding, because of the concerns that we've expressed with additional costs, doing work twice, expediting when maybe we shouldn't have. I'd like to just, because of that and for other reasons, associate myself with the comments of Commissioner Herman and state for the record that I do not believe I am making a prudency decision on this today, and this is not a rate case, and we'll do that at the normal time. Thank you.
Great. Well, thank you, Mr. Trout. Any other questions? Let me just ask my fellow commissioners here, are we prepared to make a decision? Any other discussion we want to have at this point? Okay.
I'm prepared to vote.
Good. Okay. Right, me too. Okay. Is there a motion?
Mr. Chairman, I move the commission grant the company's request for a waiver of the CPCN requirement under Public Utility Article Section 7-207 B4 little I for the construction of the transmission tap line from the existing Ringgold Catoctin line to the Garfield substation.
Great. Is there a second? Second. All in favor?
Aye.
Opposed? Motion carries.
Thank you.
Thank you.
Mr. Chairman, last item on the agenda today, item number 7, is the Office of Staff Counsel and Delmarva Power and Light Company filed a letter agreement regarding the impact of the TCJA on Delmarva Power and Light Company's rates.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is the further consideration of Delmarva Power and Light Company's filing regarding the impacts of the Tax Cuts and Job Act of 2017. This was considered originally by the Commission at the administrative meeting, I believe it was 4 weeks ago. And at the time, the Commission asked the parties to have further discussions and see if they could reach some level of agreement on the amounts in question and how to give them back to ratepayers, or flow them through the ratepayers more accurately. Staff, the company, and OPC have had discussions. OPC it did not want to proceed on the same basis as staff and the company, so there was some limits to the amounts of discussion that they participated in. That said, staff and the company have reached an agreement on what we believe the appropriate amount of the flow-through in rates should be, and that is a total of $13,844,912, consisting of operating income at $8.8 million and deferred income taxes just over $5 million. And further, that the amount of the regulatory liability that has been accruing since January 1st Through March 31st is $1,891,121. Staff and the company have further agreed that the appropriate method for returning that amount to customers is through a one-time bill credit based on actual numbers. As I said, the agreement is limited to being between staff and the company. OPC continues to maintain its own position, and they are here today to discuss that to the extent the Commission wishes to. In addition, there is still one area of disagreement between staff and the company, and that's simply with the basic concept of whether or not the regulatory liability should be flowed back to customers now or should wait until the company's next rate case.
Okay. Great, thank you. Let's see, I just have just two questions. One, just going back to to OPC's original filing, I just wanted to find out if staff had any I guess response to some of the concerns that were raised at that time. I mean, OPC did contribute quite a bit to this case. I think you would agree in identifying some other issues, but they talk about staff incorrectly looked at allowance for fund used during construction, AFUDC. Do you believe that there was an issue, a legitimate issue there? I mean, it's my understanding that's part of the gross-up factor that goes into revenue requirement. But again, is there a staff response to that concern?
I think I would like to leave that in Mr. Valcarengi's hands.
Okay.
He's much better at talking about things like that.
As far as the AFUDC is concerned, we didn't believe that there was an issue in that regard. As far as the other issue, we believe our issue is the most appropriate way to move forward. We didn't agree with the methodology that People's Counsel using starting from the company's pro forma position in a prior case. We thought that was an inappropriate basis to start. So it was just a apples to oranges type of methodology. But we believe our methodology is the most appropriate methodology to move forward.
Oh, okay. And then also that we might be looking at two different approaches here as far as how we've dealt with this, we're dealing with this case, and how we dealt with, for instance, BGE and Columbia Gas.
Well, I think the methodology that staff used is consistent with the methodology that we used in the prior cases, both in BG&E and Washington Gas Light.
Okay. And is it around just the timing issue overall? I mean, just as you defend the methodology, obviously I wanted to hear from OPC on this as well. I just wanted to
well, I think from our perspective, the basic disagreement goes into the starting point. There was a settlement in the last rate proceeding, and OPC decided to use that as a starting point, and we decided to use the per book numbers that were, I guess, you could validate as a starting point. So we use that. There's a basic disagreement as to what's the appropriate starting point as the assessment.
Okay, great, thank you. Any other questions, commissioners? All right, we'll hear from OPC.
Mr. Chairman, Commissioners, good morning, and thank you for the opportunity. We thank staff and DPL for continuing to work on this, and as staff noted, we did participate in some of the discussions, and we filed comments in response to the joint letter submitted by staff and DPL, and continue to have some concerns that we outlined in our letter. So I'll just briefly go over two matters, and then I'll move to the FIT expense concern. We do agree very much with staff that the regulatory liability component should be refunded to customers as soon as reasonably possible. We do have a disagreement, I think, with the amount of that component, which then leads into our FIT expense concern. And we also think that that component should be the entire amount from January 1st to the date that rates become effective. I think with the most recent filing, it doesn't quite capture that full amount of that value. And then there's still a question which I don't think has been fully answered in the joint filing in terms of how the revenue will be distributed to each rate class. Staff proposed two methodologies in their initial filing. The company agreed with one of those methodologies. We still maintain and agree with staff's alternative allocation method, which would distribute the amount based on revenues and exclude the GSP class. And then lastly, but I think is our main concern, is with the fit expense value. And we've asked our consultant on this matter, Mr. David Efron, to be here today to just explain that more fully and then answer any questions should the commission have it. So with that, Mr. Efron.
Yes, David Efron, a consultant to the Public Counsel. Sorry, to the People's Counsel. The first step in determining the amount of excess income taxes the company is collecting in rates is to go back and look at what was allowed in the prior rate case. The company used a method to determine that began with their per books filed test year statement of revenues and expenses, and went from that to the amount that was settled as the company's additional revenue requirement. In effect, that leaves out a whole intermediate step, namely how to get from the company's actual test year revenues and expenses to the pro forma revenues and expenses under the then present rates that were used as the basis to determine the company's revenue requirement. Every case that I have ever been in has always determined the company's revenue requirement and revenue deficiency based on the adjusted operating income, not the actual test year operating income without any pro forma adjustments for known and measurable changes. Now, in the other cases that have been used as an example, for example, Baltimore Gas and Electric, their last rate case was not settled. So there was a clear roadmap there to determine how the federal income tax expense in the company's revenue requirement was determined. If you look at what Baltimore Gas and Electric did in its submission to the commission, they started with the actual test year results, adjusted it for known and measurable changes to get to its calculated revenue deficiency based on its rebuttal position, and then adjusted that for what the commission did in its order as to the revenues and expenses that go into the revenue requirement. With Delmarva, we have a different situation because the case was settled, so we don't know exactly how the commission got from the rebuttal position to the settled revenue requirement. What we do know is that the settled revenue requirement was different than what the company's rebuttal position was, and we know by how much it was different. So to me, it's an easy matter to get from their rebuttal position to the final revenue requirement and see what the effect on income taxes was, and to make that calculation. That's what we did. If you look at the Columbia Gas filing, that's exactly what Columbia Gas did, because their last case was also settled. They began with their rebuttal position, took into account the effect of the settlement, and calculated that as the federal income tax expense that was included in their revenue requirement. That's what we've done. We believe that's consistent with what the other companies have done, and we think that the company's method has, in effect, left out that whole intermediate step and doesn't use as a basis for determining the income tax presently being collected in rates that reflects what was actually done in the last rate case and the settlement of that case.
Thank you, Mr. Efron. Are there any questions from Mr. O'Donnell?
Yeah, actually for staff, though, in response to the questions, if that's okay. One, staff respond to Mr. Efron's comments he made just now, and then two, did staff's April 6th letter clarify how the benefit allocation should be between the classes, as OPC maintains that that's still an open question?
Well, I can't answer the question with regard to how the dollars should or should not be allocated across the respective classes. I think you're...
Mr. Valgrengi, could you talk into the mic? I'm having difficulty hearing you.
All I'm saying is I can't give you an answer with respect to the appropriate allocation of cost between the classes. I think my colleague, Mr. Hoppeck, would have...
Yeah, OPC maintains that your original filing had two options for that, and that that the company prefers one. And did staff clarify that? I think that's what I heard OPC say, and I'm asking for that clarification. If you haven't already clarified it in your April 6th letter, to at least clarify it.
Yeah. I don't think it was specifically mentioned which of those options that were. My recollection and understanding is that it was the option that the company preferred among the options, the ones that staff gave. There were two of those.
Yeah, because if we make if we were to approve this after discussion, and we make a motion, we typically will make a motion that says, in accordance with staff's recommendation. But I need to know what staff's recommendation is. It's unclear to me, as OPC indicates. It's unclear to them.
And as I said, I believe the recommendation was that the rate decrease gets allocated across the board for step one, except for the regulatory liability, for which the GSP class would be excluded.
Okay. And any comments on Mr. Efron's comments?
I'll let Mr. Ralph go to respond to those.
My response would be, I think I followed a consistent approach in this case and to the other cases, BG&E and Washington Gas. And I think that the difference is there's a black box settlement, and people can make relative determinations as to what's in, what's not in, what's approved, what's not approved. I didn't think it was appropriate in this instance to go and say these adjustments would have been approved by the commission as a basis for the settlement. So I thought it was appropriate as a starting point to use the per book and then layer on the rate increase and determine this is the federal income tax impact from the rate change.
Yeah, he cites Columbia Gas, you cite BG&E and Washington Gas. Why, what's the difference?
I don't know that there's any difference.
Okay. Okay. I just was hearing comparisons of different companies' proposals, and
but he is accurate. Mr. Efron is accurate there that there was a settlement in the Columbia Gas case, the very last case. I think it was case number 9447. But a majority of those O&M adjustments and so forth, it all dovetails into staff's presentation. I don't want to say that the settlement is in line. The settlement is in line with how staff would have moved forward, if you will, but I don't think the issues are the same. Their adjustments that they present in terms of their evaluation of federal income tax are precisely the same as what staff followed. I don't think you can, what the company did is not precisely the same as what staff did. And therefore you're saying, well, this is the same, that's not the same. So we said, rather than make value decisions as to this adjustment or that adjustment, that's why we said, well, we're going to start at the starting gate at the per book and then just layer on, this is the value of the rate increase and move forward from there.
Thank you, Mr. Chairman.
Commissioner Herman.
Commissioner, in response to your question, I did state correctly where we stood on the allocation issue. And again, that would be to allocate the general rate decrease across the board to all classes, but for the regulatory liability to exclude the general, the GSP class.
Thank you.
Commissioner
Uh, with respect to the period January through April, I note that the staff recommendation is to take the January through March, take the 3 months, have that be refunded in a one-time refund. Do you have any indication as to what the level would be for a typical average residential customer? Is that on there? I'm not sure.
The average residential customer would see approximately $7.20.
$7.20.
Based on January through March.
January through March. And then you're suggesting that doing that because March is a known number at this time and April, say April 1 through 15, for example, is not known at this time.
That's correct.
And what will happen with the month of April?
It would be our position that it would sit as a regulatory liability. So in the next case, it would be staff's position that would be one of many issues that would be decided in that case.
Okay. And I see the company is there, if it's all right. If I ask the company, is it not possible to include the first half of April in that calculation, Mr. Mikeel?
It just makes trying to get these rates in quicker by April 20th hard. And that stub period, we'd have to look. I don't know that we could get it by April 20th.
Okay.
It's a lot of it is a computer issue in getting these rates in.
Okay, so I guess I was confused because I thought the effective date was May 1st, but you're telling me the requested effective date is April 20th?
Yes, on the tariffs that we filed, the requested date is April 20th.
Oh, sorry,
And
I'm looking at the wrong page.
Yeah,
I apologize.
And we noted that in our letter. And if you look at footnote 2 of the joint letter, it's got the $7.20.
I was looking at the wrong page, Mr. Mikeel. I apologize. So it's April. So it's not the full month of April. It's April 1 through 19.
Yes.
Okay.
Yes, and it's and as staff noted, and we note in footnote 3 would be a regulatory liability, and the customers would eventually get that back in the next rate proceeding.
Okay. Thank you. Sorry for the confusion. Thank you.
Commissioner Linton? I just have one more question for OPC. One, as just mentioned, we are trying to see if we can accommodate the April 20th deadline. Is there anything that you just, in the discussion with staff that you wanted to respond to at all? And, that would be my first question. Anything?
So I can go first and then turn over to Mr. Efron. Two main points, I think. So there is the April 20th date, and I think as has happened, I want to say with the Columbia case and maybe some other ones, the company could be directed to then, after 60 days, that the rates actually become effective to pass through that particular liability from, let's say, April 1st to April 20th back to ratepayers as well. So in addition to the liability that would be passed back from January 1st to, let's say, April 1st. So that's potentially one option. And then in response to the allocation of the revenue reduction, so I appreciate staff's clarification of that. We still maintain that staff's alternative allocation method is the most consistent and really makes the most sense, because if the GSP class is being excluded from the regulatory liability, staff hasn't quite made an argument as to why it should be included in the complete rate reduction. So that's still sort of unclear, and if staff's alternative allocation method was to be approved, that would consistently exclude the GSP class from both. So those are kind of two comments to that, and then in regards to the bid expense, if Mr. Efron has anything else to add.
Yes, I'd just like to say one thing briefly. Mr. Valcarengi, I believe, made the comment, something to the effect that he didn't want to get into trying to determine which of Delmarva's pro forma adjustments were accepted and which were rejected. And I agree completely with that. I did not do that. It was not necessary to attempt to do that. All that it was necessary to know was that there was a difference between Delmarva's final rebuttal position and the actual revenue increase agreed to in the settlement, and to determine the effect of that difference on the income tax being reflected in the company's rates. That's what I did, and I made no attempt to try to determine which adjustments of Delmarva's were accepted or which were rejected. It was unnecessary to attempt to do that, and I did not do so.
Okay. And the other question I would have is just you identified that you believe that there should be another million, 1.074 million greater reductions in staff. Can any of that possibly, we look at those issues at a later rate case, or is this this is the time we have to take care of?
No, a later rate case would have no bearing in this whatsoever.
Okay, that's what I thought. Okay. Well, I just wanted to thank OPC. I think you guys, the organization has done a great job in really contributing to the whole TCJA filings, and so for all the cases. So thank you. Are there any other questions? Great. We have the company. Would you like to be heard? Have any comments on this?
So I would just say that we agreed with staff and the basis that we agreed with staff pointed out that their methodology, which was not the initial methodology that we used, was consistent with the methodology that this commission had approved in the WGL case and in the BG&E case, and they wanted that consistency, and we agreed with them on that consistency. We think they were appropriate in using the starting point that they did, given the situation we were in with a black box settlement. We think this number is the appropriate number. I would point out that in the WGL case and the BG&E case, with respect to the regulatory liability, that was held over until a rate case, and so we think it should be in a rate case. Nevertheless, we've calculated the number, and the number is there should the commission want us to give the refund, and that would be the $7.20. And then I have Mr. Jay Zeminski here to respond a little bit to OPC and Mr. Efron.
Thank you. Good morning, commissioners. Just in terms of how the company approached the calculations of the federal income tax expense, that was sort of in the last case, which was a settlement. Again, we looked at the various methods that both staff and OPC used to determine that. In looking at our method versus staff, and again, staff using the same method that was approved in the BG&E and WGL case, there really were just sort of some minor differences as to how we interpreted the tax rate decrease, effective rate versus statutory rate. So we sort of worked through those and basically, again, sort of came to an agreement on their numbers. In regard to OPC's calculation, the way I interpret their schedule is as if every rate-making adjustment that the company proposed was accepted, including all the federal income tax expenses associated with adjustments, and then the subsequent rate increase that came out of that settlement was the $13.4 million. So I think it's, again, sort of agreeing as to sort of what that starting point was, and again, sort of in talking with staff and seeing OPC's method, we agreed with the way that staff calculated the amount based on what has been accepted by this commission. In regard to the tax liability questions that I think folks have had, again, I think it's our position to use sort of a known and measurable number for this credit if we're going to, the commission decides to have that liability credited in customer bills coming out of this decision. And then whatever sort of stub period we have here from April 1st to April 19th, 20th, whenever the new rates would go into effect and essentially shut off the faucet for that liability, we would deal with that liability in the next rate case, similar to what Mr. Valcarinci had suggested. So customers would get all that money, most of it now, if that's what the commission were to decide, and then just sort of this moving target residual piece would just be deferred to the next rate case, similar to what sort of BG&E and WGL have.
Great, thank you. Are there any questions for the company? Great. Well, I wanted to just thank the company again. Thank all the companies really for working so expeditiously and getting these benefits, these tax benefits back to customers. So thank you. Are we prepared to make a decision on this item? Great. Well, is there a motion?
Yes, Mr. Chairman. I would move that we accept the tariff revisions for filing with an effective date of April 20th, 2018. That we direct the company to implement a one-time fixed bill credit related to the 2018 regulatory liability for the period January 1st, 2018 through March 31st, 2018, as recommended in staff's April 6, 2018 letter and case number 9473. Direct the company to make an informational filing that discloses the actual refunds distributed to customers not more than 60 days after completion of the distribution of one-time refunds, and direct the company to make a further filing with the Commission as soon as possible if additional tax savings are identified and not addressed in the company's previous filings in this matter related to the Tax Cuts and Jobs Act of 2017.
Great. Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion is adopted. That is our last item.
That's all we have for today, Mr. Chairman.
Great. We are adjourned.
Thank you.